he's using it against me, saying that I am not allowing him to see his daughter or take his daughter, which is not the case because I have made the effort.
If he wants to see his child, then let him make a court application. Be confident that the approach you're taking is the right one.
Independent social worker and Cafcass are still using my past against me instead of the previous that I've done.
If I was to believe what you were saying, it's very unfair. They will only declare you unfit in the extreme of circumstances. Hey guys, and welcome back to the Legal Queen live show. I am your host, Tracy Maloney, aka the Legal Queen on social media. I am a practicing family law solicitor and have been for over 20 years now. During that time, I've helped so many people with their divorce, finances, who gets the house as part of the divorce kind of thing, and of course their child custody problems. If you have a problem, family law specific, that you think I could help you with, then by all means join me over on Discord, the Legal Queen. Come into the Legal Queen Lounge, pop your hand up, and I'll invite you onto the stage where hopefully I'll be able to answer your question. Now on with the show.
Basically, 4 years ago, I went to court. Social services took me. They made a lot of false allegations, which I could prove against, but it all got dismissed.
Yeah.
I basically had to make the choice of, because I was deemed, as they call, unfit.
Yeah.
Sorry.
That's okay.
They basically said that I had to make a choice of, given the fathers who was abusive towards myself and my children, one was physical and sexual towards me and everything.
Yeah.
It was emotionally abusive. I had to make the choice to let the children stay with the fathers until I'd done what they called an updated parent assessments and everything. Basically, I've worked so hard and done everything plus more in 4 years. So I took it back to court. 2 separate fathers, 3 children. My 2 eldest daughters, I won't say names, but they're with their father currently. And in the last year, they've been getting in trouble at school. They're crying. They're trying to run away from home. They're trying to self-harm.
Yeah.
And basically, I've took it back to court. And then I had to redo a parenting assessment through an independent social worker, but they've gone on all of my past. Is there any way I can prove... I've got a final hearing next week. Is there any other way I can prove that the independent social worker and Cafcass are still using my past against me instead of the previous that I've done?
I think where the social workers make a finding that you are an unfit parent, what they are looking for you to demonstrate is that you have changed your ways. Okay. Now, obviously, having worked in this sector for many, many years, I can say with complete confidence that social services will not want this to come to the finish line any quicker than it has to. If anything, they'll go the opposite way and they will extend parents so much time. They really don't want to take children away from parents. And I know there's a lot of parents watching that won't believe that. But trust me when I say that's the last thing they want. They will only declare you unfit in the extreme of circumstances. So the emphasis then is on that parent to do whatever social services are recommending, to jump through hoop after hoop after hoop. Even if you don't agree with the hoops that they're holding out for you, you've got to keep jumping through them. And when you think that you possibly can't do any more and they ask you to do more, do it. So your question to me, how do I prove that I've changed? I would hope that you've been doing what social services have asked you to do. Now, if you've done that, let me finish. Sorry, Kelly. If you have done that, then the court can't possibly make a finding that you are unfair. I'm going to suggest, and I don't know anything about your case, but I'm going to suggest that you haven't done that.
I have definitely done that, but they're still using my past against me. And I had a Cafcass, obviously, Section 7 done on all of us.
Yeah.
And they said basically the court asked for social services to do Section 7 because they finished a year ago. I'm supervised at present.
Yeah.
and social services refused to do the Section 7 report.
Yeah.
So then we had to go back to court, and Cafcass then took it on. But the problem with like the judge said, the Cafcass do it, but it's not in as much detail
Yeah.
as the social.
Uh-huh.
But however, since that, in the last 6 months, obviously I'm being supervised by a family friend as such that's mutual for us all. I'm trying to communicate with the fathers, and all I get is a physical and a verbal abuse and emails. They ignore me. If my children ring me on my voice video calls, which the court said, he ends to call it on his own accord. My sister's involved. That end, it's a big mess. However, I've done everything plus more.
Right.
But nobody seems to take what they've done. When the judge was listening, and he was very, very fair with it all, and he said, well, actually, Ms. Genny, you've done really, really well. You should be proud of yourself. There's no more you can do. We'll take it back to court for a final hearing. Then both fathers, solicitors, and I was representing myself. They changed the judge because they didn't like what the judge was saying.
Okay, so I'm going to correct a few things that you've said there, Kelly. The first thing you said, which I'm not buying, I'm going to be honest with you, is that social services refuse to do the report. They cannot refuse to do it if a judge orders it. Okay?
They did. I'm sorry, but they did,
No.
and I could send you proof of that.
No, I'm not going to believe that. If a judge orders it, they might have said to court, we don't have capacity. It's going to take us 6 months to do it. But they cannot say no to a judge, okay? Second thing that you've said is that because both the father's solicitors or both the fathers didn't like the judge or didn't like what the judge was saying, the one that said you were doing quite well, they've asked to change it. They can't do that either. Cannot do that either. It's down to the individual court who it's listed with. So I would say there's something going on there that we're not joining up the dots here. And honestly, Kelly, I'm not saying this because I don't believe you, but having done this job for so long, I know that there's something not adding up. I just know that there is. Because if you have bent over backwards, then even the fathers would have to accept that. Now, when I asked you about your relationship with social services, you then started to answer me about you're trying to connect with the dads and they give you a load of abuse. But that's not who you've got to impress. Who you have got to impress is social services, Cafcass, and the court. So your focus needs to be on them.
The socials finished a year ago.
Right.
Then they managed to move my contact through the court into the community.
Good.
And then when we're putting stuff into court,
Yeah.
they're saying that my supervisor doesn't have a say in how well I'm doing and stuff. So I don't know how else I can prove to the courts or whatever how well I am actually doing, and that now I have made a big, big change.
Well, as I say, you have to improve your relationship with Cafcass. And, if you have been appointed a supervisor that isn't allowed to relay the contact back to court, you need to get a different supervisor. Because what you're telling me, if I was to believe what you were saying, it's very unfair. And I just can't believe that the family court would set you up like that. I'll be completely honest. I just, that you have to have, you've got a solicitor, I take it. Maybe there's more that they could be doing.
I've just got one because obviously I wasn't allowed legal aid on this occasion.
Right.
So I've had to pay private, which is obviously a lot of money.
Yeah.
We've now come on, but even my solicitor, she stayed in contact with me while I was, was doing little bits with me. And I was paying her, but she wasn't representing me in court.
Yeah.
And even she said how much of a disgrace this all is. Well, then, if you had an email address, I could prove to you that social services did refuse to do that Section 7. The judge was not happy at all.
You don't have to refute. You don't have to prove that to me at all. But all I know is that social services can't overrule an order. If a judge orders it, somebody will do it. That's all I'm saying.
Yeah, no, they passed it to Cafcass, that's all. So,
okay.
So basically I need to go to social services then, and that's why they refuse.
No, I don't think you do, Kelly. That's my point. I don't think you do. I think your focus is pointed in the wrong direction. You need to be focusing on improving your relationship with Cafcass and the court. You know, I get a lot of people who are, their families involved with social services, and they will say to me, I don't like social services. I think the social worker's all wrong. I don't really care. They're the people that are going to be reporting back to the judge. So you have got to improve your relationship with them. You know, I don't advocate complaining about Cafcass and complaining about social services, because they are the independent view that the court's going to be listening to. So I don't think you need to go back to social services and demand to know why they couldn't do the report. That's not helping your case. That's the point I'm making. Do you see?
Yeah. Oh, the solicitor's taking it on now. There's just so much to it, obviously, to say on here.
Yeah, you can't say it on here. No, I appreciate that, but just try. I mean, if you know, we've spoken for a little bit of time now, but just try moving forward. You just have to know that you've got to impress Cafcass and impress the court, because you're starting from a position where they have deemed you to be unfit. So forget the dads for a second, and let's just work really hard on proving yourself to be a fit parent. I'm going to suggest that you sit down with your lawyer and say, right, how do I do that? How do I do that? Have them tell you how to do it.
They've already told me, and I've done all of that, but it's still not moving, because what the judge wants, because Cafcass is now gone, they did the Section 7, then they closed. And then they brought an independent social worker, and he did that. Then there was some, I won't say fault, some untruth in some of it. And then he's agreed where he went wrong and all that. But what the judge wants is all three parents to be amicable. I'm trying to be amicable. I stay child focused and everything, but the fathers don't.
Yeah.
But yeah, I think because I was representing myself,
yeah,
I didn't have the capacity that a legal person would have
absolutely
to put it to the judge,
Yeah,
if that makes
absolutely.
sense.
100%. And I totally get that, Kelly. And where parents don't have the money and they have to represent themselves, that's the position that they've got. You know, they can't do any more than that. But of course, if you're not legally trained, it's very difficult to represent yourself sometimes accurately, because you're not aware of what the court are actually looking for. So a lot of your submissions may have been irrelevant, or may have even damaged your case. I don't know. I can't comment on that. But I would say that, you know, if there is still a finding of you being unfit, there is still time for you to try and turn that around.
Okay, lovely. Thank you for your help.
Good luck, Kelly. Thank you. Bye-bye.
Bye.
It's difficult, guys. You know, there's a lot of you out there that are dealing with social services at the moment, and for whatever reason, you might think that, you know, they haven't got my back, or they don't believe me, or whatever. And the struggle is real. I do get that. You know, social services are incredibly busy. Like most government sectors, they're underpaid and understaffed. So they're all stretched, and all you can do is work with them the best that you can. That's all I can suggest. And whilst you might disagree with their methods and what it is that they're asking you to do it. You know, just kind of toe the line and try to do it, because ultimately it's the judge that's going to have the final say on where the children live and who they spend time with. Gossia, let me come to you next. You are on mute, but whenever you're ready. Hello.
Hello, hi.
Hi, how can I help?
I have a couple of questions. So me and my ex-partner have broken up like recently, like last month, and since then he has not made like any effort to have a relationship with our daughter or like to see her, but the effort like mostly came from my side. Like I used to call him, send him pictures, you know, and keep him updated. I even like offered if he wanted to like see her, take her, and he always has made an excuse of, oh, I don't have the money or stuff like that. But even when he said he doesn't have the money, he always went out to drink. And we're currently going through mediation, and he's using it against me, saying that I am not allowing him to see his daughter or take his daughter, which is not the case, because I have made the effort. We live like 2.5 hours away from each other, and he said he doesn't want to travel for that long because it doesn't make any sense. So I even offered to like take the baby half away so he doesn't travel, and that was still not good enough for him. And obviously I've tried making the effort so he takes her, but he didn't, and now he's using against me that I keep his daughter away from him. Does mediation see that as like, I've made the effort, he didn't want that, but now he's demanding his daughter to have her like at least 2 weeks within a month?
The first thing I'm going to say, Gossia, is if I was in your shoes, I wouldn't really care what the mediator thinks. If we understand the role of the mediator, they are there purely to assist the parties in reaching an agreement. They are there to facilitate an agreement between the parties. So it doesn't matter what they think. They're not their decision or the agreement that you, and your ex reach won't be legally binding because the mediator isn't a court of law. So I would worry less about what the mediator thinks. Your story was all about, this is what he wants. This is what he's doing. He's drinking. He doesn't really want to see his child. I am offering him contact. If I were you, I'd take a step back. Just take a step back and just let him do him. If he wants to see his child, then let him make a court application. You started your question to me by saying he doesn't want to see the child. Fine. We cannot force him to have a relationship. And I think rather than you tying yourself up in knots, trying to please him, offering him this, offering him that, going to mediation with him, worrying about what the mediator thinks, take a step back. Take a step back and you live your life, because you're the parent that's there 24/7, bringing that child up. If he wants a relationship with the child, he will. He will step up, whether you live 2.5 hours apart or whether you live 2.5 minutes apart. He'll find a way to make it work. And the reason I say this, Gossia, is because so many mums take this kind of stance where I'm doing all I can, I can't do any more, what more is going to be asked of me? And I kind of want to say, take a breath. You're doing everything that you can. Know that. Be confident that the approach you're taking is the right one. And you can do no more. You can do no more.
That's fine. If it does go to court, will because obviously I've made the effort, and if I tell them that I've made the effort and he refused to see his daughter, even will that be used against me that I've made the effort and he just didn't?
No. Again, don't worry about that. If he makes a court application, and I suspect that he probably won't, but if he does make a court application, on the first day of court, judge is going to say to him, okay, this is your application, Dad. What do you want? What contact are you asking for? He might say, I want every other weekend. Court will then look at you and go, you happy with that, Gossia? And you'll go, yep, absolutely I am. So judge will then look back at him and go, well, why are we all here then? Or if he says, Dad might say, well, she's not letting me have any contact. You'd go, yeah, I am, actually. I have offered him this. Here's a text message to prove it. I've offered him this. Here's another text message to prove it. I'm not sure why we're here, Judge. I want my child to have a relationship with him. So again, be confident that you can do no more. Okay, you're not withholding contact unreasonably. You want the child to have a relationship with their dad. He's just, for whatever reason, playing mind games, or I don't know. I don't know your case, but I just want to kind of instill in you some confidence that what you're doing sounds to me as if, you're ticking all the boxes.
Yeah. If he demands, because I've tried offering him every other weekend, and he said that's not gonna work with him because then he cannot financially be able to afford it. So he didn't agree to that, but he wants then to have her for 2 weeks straight.
Yeah.
Which to me it doesn't make sense, because then it looks like to me he's not gonna be able to financially afford it as well, because then he's missing 2 weeks of work. Because that's what he's saying, he wouldn't be apparently leaving her with anyone or anything like that. Would the judge look at it like I do, like he won't be able to
I
financially
think,
afford it, or
Gosia, you're overthinking it again. So what I would say there is you've offered him alternate weekends, and he has said no, I can't do that, but I can do 2 weeks straight. Rather than sort of saying to the court, well, I don't think he can afford that because I don't think he can take 2 weeks off work. With respect, that's none of your business. If I was in your shoes, I'd be saying to the judge, not sure that's in the best interest of the child, judge. You know, she doesn't, or he doesn't see dad regularly. And then all of a sudden we're going to have an intense 2-week block. Probably not in the best interest of the child there. And the court would agree with you. So don't get caught up in your view of his financial position, because the judge will say, well, that's got nothing to do with you, really. That's for him to decide if he can or can't afford to take 2 weeks off work. Your tact should be, I don't think this is in the best interest of the child, because they live with me and have always lived with me, and to take 2 weeks away from me at this age just wouldn't work. That's how you would approach that. And the judges are more likely to give small bite-sized chunks of contact. And how would 2 weeks work anyway? 2.5 hours away. How's he going to do the nursery run or the school run, or 2.5 hours each way?
She's only 4 months at the moment,
Oh,
so
I
she
see.
doesn't need like. I'm also like mostly concerned about like because he doesn't have like a safe space for her to sleep or anything like that, and like as you're aware, he goes out and drinks a lot. And to be honest, that seems like it's his most priority.
At 4 months old, that's very young to be taken away from mother for a solid 2 weeks. If that's what he's going to ask for, I'm not so sure that he's going to succeed. I'll be completely honest with you.
That's perfect. I just was wondering because it's in my head, like,
sure,
I know it's wrong to take her away for that long, but
sure,
obviously he doesn't understand that, so I just needed to like hear it from
no
someone
problem.
else.
All right, well, I hope that's helped.
Perfect. Thank you. Have
Gosia.
a nice day.
You too. Bye-bye. It's difficult, isn't it, where you've got one parent who's raising the children, the other parent doesn't really want to have any contact with the child. We can't force a parent to have contact. We can't make an application to the court to say, I need the other parent to have more contact. Sadly, we're not able to do that. I do get a lot of emails from particularly mums who say, I need help. You know, I'm trying to hold down a job. I'm trying to work as much as I can. I need the father to step up and to have the children, 50-50 or 60-40, whatever it might be. What can I do? And sadly, I have to say absolutely nothing. The court doesn't have the power, sadly. Steve, you're back. How can I help?
Hi, yes, Tracy. I've just got a couple of thoughts, if that's all right. And I've got
Sure.
a question. But firstly, just to say, as a dad who's been through the courts, I think any father who wants to spend time with their children will move heaven and earth. So mums can rest assured, if the dad wants contact, he will make that clear at any stage, as I did. My other thought, just on the caller before that, was talking about the allegations made against you in court. And again, just to say, the best advice my solicitor gave me at the time when I was going through this, Tracy, was words can refute an allegation, but actions speak so much louder. And there are so many courses out there that are free to people, whether it's a parenting course, whether it's a relationship course. Local councils provide them online. And I would just strongly recommend any listener who wants to refute an allegation or prove or show they are changed or a better person, to go and do those courses and to demonstrate to the courts that they are willing to do those to change and be the person that's right for the kids.
You're absolutely right, Steve. A lot of times I'm dealing with parents where the court might say, okay, let's order a parenting course. Let's order some drug testing. Let's order a psych report. Let's order some supervised contact in the first instance, and then we'll get the notes from the contact centre. And the parent is like, I'm not doing that. I haven't got a drug problem. I'm not doing a parenting course. I'm not doing anger management. And a lot of times it's like, look, don't disagree, just do it, because you want the court to give you the order that you can have contact with your child. And that's the point I was trying to make to Kelly. You may not agree with it, but just do it. The focus has to be on having a great relationship with social services, Cafcass, and then ultimately the judge. If you have a good relationship with your Cafcass officer or social services and you're doing everything and more that they're asking you to do, how can they not give you a glowing report? How can they not?
Absolutely, I think it all helps, doesn't it? But
Yeah.
coming to I waffle on a lot, Tracy. But coming to
No,
my
it's
question, you
fine.
talk about going to court doesn't have to cost a lot. You don't need to have a solicitor. But
Yes.
so, can you just tell us a bit more about what a McKenzie friend can and can't do in court? And then my other
Yeah.
question is, with work, we are just allowed to start using AI and Copilot and ChatGPT, and I'm sure there are pitfalls if you're preparing a legal case in using those. And do you have any advice, really?
Absolutely. So to answer your first question about a McKenzie friend, the McKenzie friend is somebody that would come into court with you to give you moral support, but they're not allowed to advocate on your behalf. They are simply there to take notes. So if you are representing yourself, you might be consumed with delivering your argument. And as the judge is talking or the other side is saying things, you can't do it both. So typically, the McKenzie friend will come into court and literally be your note taker, as well as give you a little bit of support. That is it. You do now have what's called a professional McKenzie friend, where they will speak on your behalf. They will charge you as well, and they will speak on your behalf. They're usually people that are going through the legal system in order to become qualified. So they have a little bit of legal knowledge, but they do have to request an audience with the court. It's not automatically granted to them. So there are two different types of McKenzie friends. My view is that if you need support in court, by all means, ask for a McKenzie friend to come in with you. But for advice, etc., try to see a solicitor. I've worked with a few professional McKenzie friends, and whilst there's been nothing wrong, there are some gaps in their knowledge, is what I would say there. And then your second question.
That's really helpful. Thank you.
That's okay. Your second question, Steve, which is super important. So for those of you on Facebook, Steve asked about the pitfalls in using AI or ChatGPT in order to help you prepare your case. It's not going to be tailored to you. It's going to give you a very generic response. Even if you feed it chapter and verse of your matter, you are feeding it from your perspective. You know, imagine a judge. A judge has the ability to see both sides of the picture and then makes the decision. If you are feeding your information into ChatGPT, you are only feeding them your version of it. So you are going to get a very one-sided case back, and definitely a generic one, but not one that I would argue is bespoke to you, which is why I don't worry about AI in family law, because family law for me still comes down to being a people's law. We really do have to tap into the emotive reasons as to why we're making the litigation behind this, and AI misses that, in my view.
That's really helpful. Thank you, Tracy. I'll carry on listening.
No problem. Thank you, Steve. Elav, I'll just take you off mute. What's your question, Elav?
Hi, Queen. So my question is more on the financial side of things. I
Yes.
fled in November due to abuse. We've been together for 19 years. He has a company outside IRA 35, which I am a shareholder, but have since been blocked from that company, so I'm not getting any dividends. So he lost his job, or rather the contract ended sometime in May last year, and he was getting offers and declined those offers, saying that the money was low, it's not equivalent to what he's worth.
Yeah.
He then went on to take debt to pay for the monthly direct debits for the mortgage, electricity, and things like that. So now that debt is about 40K, and he has also not been paying things like corporation tax and VAT. So my question is, when we then go to the financial remedy,
Yeah.
am I going to be penalized, or is the company debt also going to be included on our financial settlement?
Okay, so essentially, your question is what role, I suppose, or what part will company debt play in the divorce settlement? If the company is a limited company, then it's its
It
own.
is.
Yeah, so it's its own entity, and the company debts will remain the company debts. Okay, it really has no bearing on the divorce. Any tax implications, like non-payment of, let's say, corporation tax or VAT, will stay with the company. They aren't part of the family court proceedings. Where the lines can get blurred a little bit is obviously if parties are directors. And sometimes what happens is families will remortgage their property, their home, the family home, to put into the business. Now, that adds a layer of complexity that I would say you have to get legal advice on for things like that. But the general answer to your question is that the company, think of the company as a third party to this marriage. It will not be included in family court. It's responsible for its own debt, the actual company, and it won't be a party to the proceedings. Okay?
Okay.
Does
So
that help?
even if he says I used some of the money to do things around the house, I'm not a director, he's the director.
Yeah. So, sorry, carry on with your question. He's saying, I've taken money from the company to spend on the property and
Yeah.
what's the question?
So I should be also liable for payments of that corporation tax and VAT that he
Well,
has not paid.
No, because as a director to the company, he made the decision. He made the decision to withdraw money from the company bank account, which is most likely been declared as a dividend for him.
Yes.
And he has that, so it's an income, it's his wage, his salary, and he has then chosen to use that salary to put into the property. That's his decision. You know, you are not a director of that company, so you can't make those decisions. So he can't now hold you liable for the fact that the company can't pay its corporation tax or its VAT. That will land with him as a director. Okay?
Perfect. Okay. Yeah. And if I want help from you, like detailed help, specifically on the financial side, because I've applied for the financial settlement with the courts, and we have our date in August.
Yes.
The first appointment in August. If I just want advice specifically on that,
Yes.
can I get that like on the first appointment, or would I need to do an inquiry with you first, then go through the advice as a second
So
appointment?
generally, the first consultations with me, they last about an hour, and we are always able to cover off everything. Okay, so as long as you have the answers to my questions, and what I would be asking would be, you know, age of both of you, what you both earn, the value of your pensions, any equity in the home, what debts we've got, etc., you know, how much he's taking per month. We can generally wrap it all up in the first consultation. And then the options I give my clients are A, we can do it all for you, and this is what we need to be doing. Or B, if budget is an issue, and it is for a lot of people, then you need to be doing this yourself. And then, you know, sort of the last 10 minutes of the consultation, I oftentimes will help the individual tell them how they do it themselves. This is the form that you need to fill out. This is how much the court fee is going to be, blah, 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 blah. Okay, so we can tailor it to whatever you need it to be. But yes, I mean, we can get an awful lot covered in an hour. A lot of my consultations, when people are ringing me, and they just want to know, like Andy came on before, and he kind of just wants to know, you know, am I entitled to 50% or 60%? A lot of times we're wrapping that up in about 30, 35 minutes. Because obviously I've been doing this a long time, so I know what questions to ask, and I'm very familiar with what the courts, the decisions the courts are handing down. For more detailed consultations, they will go on for the hour. Okay?
Perfect.
All right.
Yeah, I think I'll need that for sure.
No problem.
Thank you so much.
A pleasure.
This is really good.
Okay. All right then. Take care. Bye-bye.
Cheers. Thank you. Bye-bye.
Right, assist, let me come to you. I'm just going to take you off mute. How is it I can help?
Hi Tracy, I have
Hello.
spoken to you before, but changed my name just because it's going out on
Yeah,
to the
absolutely.
platforms. I don't want to be identified. So yeah,
That's
so I'm
good.
going through the finances at the moment.
Yes.
We've had the FDA. We're going for FDR. It's not until November because they need to do a pensions on divorce expert questionnaire.
Yes.
But it's kind of around that. So you mentioned earlier on to the gentleman who called saying that, you know, because he's likely to get, he would maybe get a 60-40 split in his favour.
Yeah.
I'm wondering, you know, if so in my example, I'm the bigger earner.
Yes.
But his pensions are bigger. Now he works full time and everything, so he's not unemployed and is not reliant on me for any money. He's rehoused himself by renting somewhere else. Is he likely to get, because I only want a 50-50 split, but he only wants to split the marital home 50-50 and we each keep our own pensions. But I'm not agreeing to that without knowing what his pensions are worth.
Good.
Is he, that was advice I was given by a solicitor first off, because I'd initially said, you sign the house over to me and I'll leave your pension alone. And she told me off. Is he likely to get a bigger split, even though I earn more money than him, even though he can manage his own finances anyway and is in full-time employment?
Yeah, so it depends. So let me give you an example, and please don't give me your specific details on this. But let's say that you're on 100 grand, okay, a year. What the court's then going to look at is, what's your mortgage raising capacity? Generally, with a good credit rating, we can usually get 4 times. And we're not mortgage advisors, but you know that's what clients are sort of telling us. So then we know, okay, you could go off and get a house for 400, or you can get a mortgage, for 400. And let's say his income is 50. Now, that's still a really good income, but his mortgage raising capacity is only 200, okay? Then we're going to look at the age of the parties. If we're, let's say, both mid-50s, well, we're not going to get a 25, 30-year mortgage at that stage. So now we have to look at affordability. And then we look to the equity that's in the property. So if we've only got, I don't know, 100 grand of equity, it may be that he gets more than 50%. Because he's only got a short mortgage term and he's not going to get a bigger mortgage as you are. And for the area that you live in, it might be that he needs 300 grand to buy a house. But if you've got 600 grand in the property by way of equity, then it could be that you still get 50-50. Do you see? Because by giving you both 300,000, it doesn't really matter what his mortgage raising capacity is. So that's where it's still very bespoke to you. So he is a little bit more vulnerable than you because he doesn't earn as much as you, but it's relative to you as a couple. Because I don't know how much equity you've got in the property. And whilst you say that you earn more than him, he could still be on a very good income.
Yeah, great. Yeah, he is still on a very good income. That's the thing. So I was wondering if, you know, he can still afford to raise a mortgage and everything in the area for him. But brilliant. I was just nervous that because I earn more money and his income is topped up because he draws down on one of the pensions as well, you see.
I see. Okay. So that might then affect any pension share that's made. Because if we're relying on his income, including the pension that he draws down on, we don't want to be taking that pension away from him if it means that his income then significantly drops and he then starts asking for spousal maintenance. So the advice you've been given is solid because it's like, well, let's just wait until we get the actuary's report. Let's just see what the outcome of that is before we start to put an offer forward as to how this matter should settle.
Yeah. Okay. That's great. Right. Thank you, Tracy.
Lovely. No problem. Thanks so much. Bye. M. Rogers, let me come to you. I'm just going to take you off mute. There we go. What's your question?
Hiya. So it's not actually regarding me, it's regarding one of my very close friends.
Yes.
He doesn't really know what to do. So I did message you on Facebook yesterday and it said to email you, but as far as I know, my emails have been bouncing to literally everyone.
Oh, bless you.
so I thought I'd just quickly jump on here.
Sure.
So I'll read you out the message.
Yeah.
So I think that's just like the best way forward.
Okay.
It says, "Hi, sweet. I've got a friend who's in a bit of a sticky situation. He had social services involved with him, the baby mum, and his daughter. He had lots of evidence against her, but it was never looked at due to her having more evidence against him. Social services said that he can have contact as long as it's supervised, but the baby mum actually failed to show up to a lot of the appointments on time or never showed. In the end, he was told no contact because he did actually, in fact, lose his temper. He went about 6 months without seeing his daughter. He was growing up, and he had enough. He bit. He wasn't showing any violence towards her or the baby, but he just basically said, 'This is an effing joke,' and they saw that as threatening behaviour.
Yep.
In the end, he was told no contact and nothing like that at all.
Yep.
He ended up moving up north to get away from it because baby mum kept calling the police on him.
Yeah.
And saying that he was stood outside of her home, which was never true. Sorry, it's my daughter.
It's all right.
But social services have now closed the case.
Yep.
And she then got in contact with him and said for him to move back down to Kent and give things another go. He did voice his worries and concerns, like, no, because I could go to prison if you was to turn on me again, blah, blah, blah. Turns out she has now turned on him and has kicked him out of their home.
Yeah.
But he's been there for a year.
Uh-huh.
He moved back last year. And he now feels like he hasn't got a leg to stand on. He wants to see his daughter. That's all he wants. He pays for her.
Yeah.
He does everything that he possibly can. The mum had a baby 14 years ago. Not his daughter, but another baby with another man. And she got taken off of her when she was a couple of weeks old.
Yeah.
And was placed under the care of Nan.
Yeah.
And mum was actually then sectioned for mental health.
So what's your question of me? What's your question? I don't need any more context.
Has he got any chance of seeing his daughter, whether it be for a contact centre? Is there a chance of him getting prison time because obviously he has made contact to see his daughter?
Okay, so let's break it down. The Children's Act, which is the piece of law that will be used to answer your question, is very clear in that each child has a right to have a relationship with both parents. Okay, so it's the child's. Hang on, let me finish. It's the child's right to have a relationship with both parents. So that's what the law is stating. The problem, however, in this case is the parents. They're toxic. They just cannot get on. So and that's why social services have said no contact, because initially he had, the way you've explained that story to me, he had his view of what was right and what was wrong. And he decided, no, I'm not doing this anymore. And off he went up north and did whatever it was that he felt was the right thing to do and didn't see his child for 6 months. Probably not a great move, okay? Mum has history, she's been sectioned. She's had a child removed from her already. That really isn't relevant in today's case because it sounded like that happened an awful long time ago, and I wouldn't encourage Dad to bring that up. But she's got issues with him, so she's calling the police and making allegations that simply aren't true. So going to court to get a contact order probably is going to fail while we have this ongoing toxicity between the parents. And what I would be suggesting is that they need to look at their co-parenting relationship before we do anything else. And of course, that sounds, the way you've described the story, to be near on impossible because these guys are a million miles apart. But that would be my suggestion. We've got to work on the co-parenting here. Because, he can go to court and he can say, it's the child's right. I'm the dad. I should be having contact with her. Absolutely. Yeah, you should. But then Mum's like, but he disappears and I can't rely on him and he's violent, he's aggressive and, he said some horrible things to me, and the court will say, yeah, you're right too. So any order this court makes just isn't going to work because the co-parenting is so bad.
Yeah.
So then it's down to them. Then it's down to them as adults to think, right, how do we fix this? You know, do we need to go to some parenting classes? There's all kinds of free courses that Steve mentioned earlier. One of them is the separated parents plan that they go to individually. Is she willing to do that? I don't know. Mediation is a lot less hostile than court. Because in mediation, if she's willing to do that, we start to explore where that co-parenting is breaking down. You know, if they're willing to put the effort into their relationship, I guarantee you, if their relationship improves, then the child contact will dramatically improve. And that it may be that they don't even need to go to court for an order. But the way you've described it there, I would suggest that both parents just need to reflect on their own behaviour for just a hot minute before we go rushing off to see the judge.
He has tried his hardest to keep things calm, keep things civil.
Yeah.
And she's blocking him, unblocking him, ignoring him for a week.
Yeah.
So he just wants to know how his daughter's doing.
Yeah.
That's all it literally is. He just wants to see her. He's supposed to see her last weekend. She didn't show.
Yeah.
He was supposed to see her tomorrow.
Yeah.
And she's texted him this morning and gone, you don't deserve to see her. You haven't asked how she was. But that's because she had blocked him.
Yeah.
And none of the messages were going through.
Yeah. Mum's clearly angry, and she's just not in that headspace at the moment, is she? So he's going to be banging his head against a brick wall until we can try to sort of, you know, get Mum to chill and relax a little bit. Look, I mean, what I'm telling you, Em, is an age-old problem, and why a lot of the children's applications are made to the court. It's because the parents the co-parenting is completely gone. So bless him, he has got an uphill battle, but rather than go to court, try some other remedies, you know, mediation, parenting programs, loads of free courses out there. And maybe if he starts doing them and saying to Mum, look, I get it, you've got some issues with me, trust issues, whatever it might be. I'm not saying he has to agree with Mum, but if he just starts doing the courses, showing Mum that he's done them, she might soften, she might not. I mean, I don't know this woman. She might not, and it might not work. But I think it's a good place to start to try.
Perfect.
All right.
Perfect.
Thanks,
Thank you so much. I'll let him know.
Okay, thanks.
Thank you.
Bye.